Welcome to War Story Wednesdays. Today let's talk about an as-is sale. Now, back in the olden days, you could sell a property as is, and it really meant buyer beware. You were buying a pig in a poke if you could find the poke and if you had a pig. Well, that changed a lot in California. In fact, back in the olden days, you could have a one-page contract, and a real estate broker could simply say, agent suggests buyer gets all inspections necessary to completely satisfy the buyer with respect to the condition of the property. And that was it. Not so much anymore. Because we've got statutory provisions that require a transfer disclosure statement. And that TDS has got a lot of questions in it where the seller is required to respond and advise the buyer about the property, to describe its characteristics, really to describe its flaws. But if you want to sell a property as is, without going through the drill of having inspections made or to fill out the form, can you? In one case, not so long ago, a seller did just that, created an as-is purchase, and included language in that purchase agreement that said that the seller nor the seller's broker were making any representations, express or implied, about the condition of the property. And that if the buyer wanted to learn about the property, the buyer would have to conduct its own inspections at its own cost and not rely on anything from the seller or the broker. The buyer, of course, bought the property and, don't you know it, found problems in the slab, in the foundation, in the flooring, and sued. The trial court looked at the purchase agreement, looked at the as-is provision, looked at the waiver of any claims language that was in it, and said, too bad, Mr. Buyer, you agreed that you were buying this property as is. And you had the duty to do that investigation. You assumed the risk that there would be something there that was undisclosed. The buyer appealed, and the Court of Appeal looked at that scenario differently. The Court of Appeal first addressed the issue of whether or not the transfer disclosure statutes, 1102 in the Civil Code, could be waived at all, because some statutory provisions that give protections to a class in the public cannot be waived as a matter of public policy. It turns out that a real estate purchase agreement and the transfer disclosure language in the statute is not something that is deemed a public purpose and can indeed be waived. Okay. So if you can waive the obligation to provide a TDS and waive the obligation to make those statutory disclosures, what's the language in the waiver that you use? Here, it was fairly broad, right? Waived all representations express or implied about the condition of the property. But the Court of Appeal said, you know, to have a waiver, it has to be knowing, voluntary, and intelligent. Knowing means that you have to describe all of the claims that are being waived. And in this case, wouldn't that include claims regarding negligent misrepresentations or unknown factors in the real estate? It is against public policy to waive intentional misrepresentations. You can't lie knowing that you're lying and have a provision in the agreement that says you can't be sued for having lied. You can make a mistake, you can be negligent in what you represent, and you can create a waiver of liability for your negligence. But you have to be very express in that waiver that the claims that are being waived include negligence and negligent misrepresentations. This waiver didn't do that, and the seller was found responsible. In terms of real estate transactions, it has been my experience that the courts look to the substance of the representations that are being made And even if there was an as-is provision, and even if there was waiver language, like in this case, I think that a seller or a real estate broker will be incredibly hard-pressed to take protection behind waiving the rights of a buyer to sue because of a known misrepresentation. Don't rely on a waiver.